All right, welcome everyone and thank you for attending our webinar today around navigating workforce issues around COVID-19. My name is Ethan Barraclough from BDO. This continues our series of webinars around the impacts of COVID-19 on businesses and employers, along with providing updates on the ever-changing layout of the JobKeeper scheme. Over the past few weeks, we have been receiving numerous questions from employers around employment law matters and the impacts of the JobKeeper scheme. To provide further clarity around these matters, we are fortunate to partner with employment law experts Paul Dugan and Kylie Dunn of DMAW Lawyers to present this session today. Thank you both for being part of this session today. Before we commence, there's just a few housekeeping matters to run through with the webinar. If you have any questions throughout, please type them in the question box as we go through the session. We have received many questions in advance of the session. We will endeavour to cover these off as we go. We'll try and keep questions to the end just so we make sure we get through all the content in the approximate hour that we have today. We've also put everyone's microphones on mute just to avoid any background noise. As I mentioned, please feel free to leave questions in the chat box as we go. Just with the prior sort of webinars that we have carried out and dependent on sort of your bandwidth and internet speed, you may encounter some speed and audio issues throughout the presentation. Please don't be too concerned if this occurs, as a copy of the presentation and slides will be available to all attendees following this. And finally, just in relation to the session today, information in particular on the JobKeeper scheme is being released on a daily basis on how this will practically work for employers. The information presented today is what is currently available, and we're still waiting for further information around certain areas. We'll highlight these areas of uncertainty throughout the session. So with that in mind, we'll kick off into the session today. So just from an overview perspective of what we're covering off today, we'll talk initially around the JobKeeper wage subsidy scheme. So this has been obviously quite topical for employers and business owners at the moment. We'll work through some of the practical sides of that today, eligibility, and just try to provide a bit more clarity. So as a business owner or employer, you've got some clarity to take away from this on eligibility and practical sides of it moving forward. With the assistance of obviously Paul and Kylie, we'll then touch on various sort of employment law matters, in particular with the JobKeeper and sort of how that affects around decision-making directions and the flexibility of the Fair Work Act. There'll also be some areas around sort of the modern awards and changes there. So in particular, this unpaid pandemic leave that will be introduced, along with how to structure sort of annual leave arrangements with staff. And then finally, we'll look at sort of strategies for managing employment arrangements. These have been very topical matters on how to structure sort of decisions and strategies with staff throughout this whole sort of pandemic. And then we'll leave sort of questions and discussions at the end. So like I said, please feel free throughout to drop questions in the chat box, and then we'll look to navigate through them right at the end. So with that in mind, I'll pass over to you, Kylie, to introduce the JobKeeper scheme.
Thank you, Ethan. So as I think we all know, the JobKeeper wage subsidy scheme was first announced by the federal government back on the 30th of March. And I think we also all know that the legislation did pass last week on the 8th of April to bring that scheme into effect, with effect from the 9th of April. And at this stage, it's expected to operate until late September. And I wanted to start by talking a little bit about some of the eligibility requirements for businesses. There's essentially two tests. The first is a location test, which is relatively straightforward. The test is that on the 1st of March, the business either carried on business in Australia, or if it was a not-for-profit, it pursued objectives principally in Australia. The second test, which is more complicated, and Ethan's going to talk to it more than me, is the declining turnover test. And I wanted to briefly just say something about the three thresholds, which are on the slide there. So businesses with an annual turnover of less than $1 billion, it's 30%. Businesses with an annual turnover of more than $1 billion, it's 50%. and charities registered with the Australian Charities and Not-for-Profit Commission, the threshold is 15%. I'm now going to hand back to Ethan to talk a little bit about how this turnover test is assessed.
Yep, thank you, Kylie. So just wrapping up on sort of the last point of the slide there, we had a question that came through prior just around sort of how this impacts non-for-profit. So you would have seen there that if you are a non-for-profit and registered as a charity with the commission there, that obviously the reduction in turnover is 15%. If you're a non-for-profit, such as an industry body or an organisation like that, you'll still be referring to the 30% like any normal business. So hopefully that covers off that question there. So moving on to sort of the turnover test and how that's assessed, this has been sort of the area that I think has provided a lot of uncertainty to employers on, how you are to sort of substantiate that you will be eligible for the JobKeeper scheme. So we're seeing a lot more come out from this over the past few days around the legislation and how this will look moving forward. So obviously the key around this GST turnover is substantiating the 30% reduction in turnover. The key around this is the word projected, and you'll see sort of on the slides there some details on how that will work. So effectively, as an employer, what you need to be looking at for eligibility is what your projected GST turnover looks like across sort of the next 6 months. Obviously, the JobKeeper has been effective as of the 30th of March. So in particular, to be eligible for the JobKeeper from day one, we really need to be looking at sort of the GST turnover, one of the month of April, and then also across the quarter of April to June. So there's been sort of plenty of questions come through in advance around this. I'll just sort of touch on a few while we're talking through this at the moment. So one of the questions was around if sort of submitting a quarterly BAS and would not be able to show the 30% decline until the June BAS. How do we prove this earlier to the ATO on eligibility? So what we need to be looking at from this projected turnover is, I guess, either a calendar month or applicable quarter, and compare that to the comparable actual period of last year. So for example, you could look at the month of April and project that your turnover will be less than 30%, or there'll be a 30% or greater reduction on the comparable period of last year. Another option would be to look at the quarter of April to June, and then what you need to be able to substantiate is that you project that the month or quarter there'll be a reduction of 30% or greater in turnover compared to the comparable period of last year. So we've had a lot of questions around, the BAS cycle. Some people will lodge monthly, some people will lodge quarterly. That's really just sort of a base case to test sort of your projected turnover. So you might be a quarterly remitter of GST. You can still sort of look at your projected turnover for April for the month, and if that's going to be 30% or greater less than April of last year, you're going to be sort of eligible for the JobKeeper payment. So another question we've got quite a lot on is, well, if I don't satisfy it for April, the month, you can obviously look at the quarter as a whole. But what happens if we don't satisfy either of them? You should really then be looking at for the month of May onwards, and it may just be that you're not eligible for the JobKeeper until the month of May onwards. So hopefully that provides a bit more clarity. Like I said, the key is around projected, and it's a self-assessment process. So we'll provide a bit more detail further on how the application process works, but it's really being able to self-assess that your projected turnover will be a 30% or greater reduction, and that will open up sort of the eligibility for the JobKeeper. Moving on, there's just a few other areas around the turnover assessment that are worth to note. So if you, once you satisfy the eligibility criteria, so for example, if you were to satisfy for the month of April that you're eligible for the JobKeeper, you are then eligible for the full 6-month period running through to the end of September. So it's really a case of once you're in and eligible, there's no sort of further testing required. you'll need to report as you go revenue figures, but that is sort of one of the benefits of the scheme. Similarly, if you were to satisfy, for example, for the month of May onwards, you would then be in for May onwards to the end of September for a 5-month period. So more will be released on sort of the submission process and how that works, but it's effectively, once you can satisfy it, you're in for that period then onwards. A few other important areas to note around if you're potentially sort of a corporate group where they're looking to sort of aggregate turnover amounts as part of a corporate group. So that's more for entities who prepare tax returns on a consolidated basis and alike. So if you are in that sort of situation, it's just working through the applicable areas there. Another area has been around, well, how do I sort of project my turnover? So the key there is around what you would potentially be reporting in your BAS lodgement. So some people might be reporting on an accrual basis, some might be reporting on a cash basis. So effectively, in simplistic terms, it's going to be sort of, the invoices, revenue that you would report in your BAS, including GST. So, what I can suggest and advise is that you try and map out over the next sort of few months, April, May and June, what that would potentially look like in your business to see, when you're potentially going to be able to satisfy the 30% principal for a month or the quarter or then a subsequent month down the track. And then there's also sort of some modifications around what comes in from a GST turnover perspective. They are quite detailed and we won't go into them in too much detail today, but these cover off just sort of related party transactions and things like that alike. Another area, just moving on from there, is just around businesses who potentially might not be able to satisfy the 30% test, given that they've had sort of significant change in their business from the prior financial year as a comparable period. So this is what they're calling the alternative test, which was in the legislation that was released last week. So this is going to apply where, for example, this might be the first year of your business operating. You may have acquired a business throughout the years, so comparing the revenue to a comparable period from last year may not work. So if you are in this position, this doesn't mean that you won't be able to access the JobKeeper because you can't satisfy the 30% principal. All it requires is that you need to have a look at this alternative test, and it's going to be through the application process that you're providing additional sort of information to substantiate to the Commissioner that without these unforeseen factors, you then would have been able to sort of satisfy the 30% principal. So if you are in that sort of position, I just suggest you reach out to obviously a tax advisor or someone like that to just get the appropriate advice around that. So in covering off on that, I might just throw it to you now, Paul, to talk further through the eligibility requirements.
Thanks, Ethan. Perhaps just touching briefly on that last point in terms of potential alternative tests. I think an example which is in the explanatory material is an agricultural business which might have been trading in drought conditions in 2019 and therefore atypically in terms of its turnover, and perhaps has returned to normal trading conditions at the beginning of this year. Presumably then one would be able to compare the usual trading conditions at the beginning of this year to the projections for the purposes of the projected GST going forward. So that was just one of the examples that was relevant to that potential alternative test. So the other thing to remember about that in terms of whether you satisfy the test is that at least for the initial period, the ATO has the capacity to make transitional payments if it considers that the information is such that it's reasonable for them to do so based on that information. However, in respect of that and in respect of your overall qualification or eligibility, it's important to know that just because the ATO gives you the tick based on the information that you've provided, that's not the end of it. At the end of the day, you have to satisfy the test as a matter of fact and law, which highlights the importance of ensuring that the information that you provide by way of projections and by way of in relation to your eligible employees that we'll touch on a little bit later is reasonably based and accurate, because otherwise you could be exposed to having to repay with general interest charges and also other potential consequences such as liability for penalties, particularly if you rely upon that acceptance for the purpose of giving JobKeeper enabling directions, which we'll talk about later. So I think that highlights the importance of getting some competent internal and or external advice about ensuring that you are providing the requisite information and that you, as a matter of fact and law, do qualify. So, in terms of the criteria that employees must satisfy, in respect of a particular fortnight, they must be employed by the entity. Now that entity extends to any other entity that the employee might have been employed with inside a wholly owned corporate group, for example, or in the event there's been a transmission or transfer of a business in that period of time, provided that they were employed within the same business. It extends to permanent full-time and part-time employees and also to long-term casuals. And we'll talk a little bit about what long-term casuals are in a moment. And then there are some obvious straightforward criteria such as they must be at least 16 years old and Australian citizens or the holders of a prescribed visa.
Just one question that came in, Paul, prior to the session was around if sort of an employee's got two employers and sort of the eligibility. So I guess my understanding with that is obviously as an employee, you're only eligible to sort of one JobKeeper payment. So we'll talk through, I guess, shortly, this nomination notice, but effectively, you know, the employer will be nominating that they'll receive the JobKeeper from one employer only.
That's right. You can't receive a JobKeeper payment if the employee has nominated in respect of any other employer. So there's not a doubling up process that can be entered into there at all. So I guess that then feeds into the next point about, or the next eligibility requirement, is that the employee must give a nomination notice stating that they satisfy all of the eligibility requirements and that they agree to be nominated for the purposes of the scheme. And administratively, which I think we're probably going to touch on briefly later, the employer provides a copy of that notice to the employee to be completed. And as some of you may have seen, I think yesterday in the Financial Review, there was an article suggesting that there was potentially a loophole here in that employers were not required to provide this notice or to then go on to claim the JobKeeper payment in respect of all of their employees. And the suggestion was that employers might then be able to use that as a lever for extracting agreements for changes in terms and conditions. Now that's possible and it's not dealt with specifically in the legislation, but I think you'd want to be very careful before doing that because you might fall foul of other provisions of the Fair Work Act and other potential liabilities, such as, for example, alleged discrimination or taking adverse action against the employee for unlawful reasons. So a cautionary note there. And we've already mentioned that they must not be receiving a JobKeeper payment from another employer. And then there are some other exceptions where an employee is on paid parental leave or receiving workers' compensation.
And just finally, with that nomination notice, Paul, a lot of stuff I've been reading that if you are sort of to get, you know, subsidised for the JobKeeper for the month of April, so they'll obviously be paid in early May. There's been a bit over the last few days just come about getting sort of these nomination notices in place by the end of the month for the first round of sort of payments back to the employer.
That's right. I think one of the questions that came through before the webinar started was in respect of whether you were required to actually pay an employee or whether you could wait until you receive the JobKeeper payment. And it's clear that you are required to actually pay the employee in respect of the fortnight, the minimum amount, which we'll come to in a moment. You can't simply nominate, put the employee effectively on the books, as it were, and then await the payment from the JobKeeper scheme. Which I think brings us on to talking about long-term casuals. I mentioned before that long-term casuals are eligible to participate in the scheme, provided that they were employed on a regular or systematic basis during the 12-month period ending 1 March 2020. One aspect of that is it's important to note that they don't have to have been employed for the whole of that period. So provided that at some point during that 12-month period they were employed on a regular and systematic basis, then they can be nominated for and qualify the employer in respect of receiving a JobKeeper payment in relation to them. Now, there's as many of you probably would be aware, there's been a fair bit of controversy about what a casual employee is or what's a regular and systematic casual, and giving rise to potential problems with whether a person is entitled to unfair dismissal rights, whether they're entitled to annual leave, albeit that they're called a casual. So just a cautionary note here that I think you need to be very careful before nominating in respect of a casual employee to identify whether they are regular and systematic casuals, which really boils down to, do they have a roster or another system or history of work during that relevant period that shows that they have an ongoing expectation of regular work, rather than being what we would call true common law casuals who just work on an ad hoc basis as and when required. Because otherwise, first of all, you might be nominating in respect of someone and receiving a payment that you're not entitled to, which exposes you to the sorts of issues I spoke about a moment ago. But also, you might then be effectively making admissions or acknowledgements that might be used against you in the future in respect of this person's employment status, therefore exposing yourself to unfair dismissal claims, leave entitlements, and so on, because you have effectively acknowledged that this person is a regular and systematic casual. So just a cautionary note there. So moving on to further eligibility requirements in respect of employees. I've spoken briefly already about the capacity, or effectively an employee is deemed to have been employed by the same entity in the event that they were employed in a different entity but within the same wholly owned corporate group, or in the same business, which really caters for your transfer of business type of situation. It applies to employees who have been stood down since the 1st of March 2020, and I think we had a question relating to someone who might have been stood down before then. The answer to that question is there is no entitlement to claim a JobKeeper payment in respect of that person. It's only if they've been stood down since then. Also, similarly, it applies to employees who are made redundant after that date in the event that they are re-employed. And this raises some potentially interesting issues about what's the basis of that person's new employment, continuity of service, what happens in respect of termination payments that have already been made, and so on. And the short answer to that is that except for in South Australia at least, and I think in most other states, long service leave purposes, it would be a new contract of employment, so there would be no continuity of employment, and therefore the employee would not have continuity of service for the purpose of calculating those entitlements in the future if they were to be terminated or made redundant in the future. In respect of long service leave, if they are re-employed within 2 months of having been made redundant, their service is deemed to be continuous, but if they've been paid out their entitlement, that would be deducted from whatever their future entitlements were. A couple of things I think to think about here is, well, if I am re-employing someone, at what terms should I do that? And I think it would be prudent to look at potentially engaging someone on a casual basis, and or alternatively on a maximum term or fixed term basis, which is linked to the period of the likely period of the JobKeeper scheme, so that at the end of that period of employment, you won't be dismissing them, and therefore you won't potentially be exposed to termination claims. And I think it would also be prudent to include in any new contract of employment specific acknowledgements about these sorts of things, i.e. that the employee understands that their service is not continuous from their previous period of employment, and that therefore they're not double dipping in respect of these sorts of entitlements. And then finally, on this aspect of it, as many of you probably know, it's not only employees in respect of whom JobKeeper payments can be validly claimed. In respect of one non-employee business owner or a shareholder or a director or a partner or to that effect, i.e. a person who is not an employee but who is actively involved in the business in those capacities, a claim can be made in respect of one person in respect of each employer entity in that category. In which case, very much the same eligibility requirements will apply.
Yeah, with that, Paul, we've had a lot of sort of questions and feedback on that sort of the past few weeks, and I think I've had certain scenarios where sort of if it's a sole trader or director or a shareholder of a company's thought they can put themselves on the payroll to get access to the JobKeeper. Obviously, the key when we come back to it is being employed as of the 1st of March, so you're not going to be able to satisfy that. So here's sort of the fallback, which is obviously a good option if you're not sort of taking a wage from the business, as long as you can obviously satisfy it. Subject to one shareholder, one partner, there's obviously means to get access to the JobKeeper.
That's right. If you've been actively participating in the business, if you're a silent partner or a non-executive director, for example, then it's unlikely that you would qualify in that category.
All right, well, I'm going to talk a little bit about how the scheme is going to be working in practice. And essentially, it's going to operate as a retrospective wage subsidy in respect of ongoing fortnightly periods starting from the 30th of March and ending on the 27th of September. And so the ATO is going to be reimbursing businesses $1,500 gross per fortnight for every eligible employee, and it will make that reimbursement within 14 days of the end of the calendar month in which that fortnight appears. And the sum of $1,500 is approximately 70% of the national median wage. It's also approximately 100% of the median wage in some of the most affected industries, being retail and hospitality. So if you do receive the subsidy, the JobKeeper payment, the question then obviously is, well, what do you have to pay your employees? And it depends whether they're still working or whether they've still, if they've already been stood down, and the amount that they're currently earning. So employees are treated equally regardless of whether they are employed full-time, part-time, or they're long-term casuals. There's no pro-ratering applicable. Employees who are earning more than $1,500 a fortnight will continue to receive their normal remuneration under whatever employment arrangement currently applies. And so in that context, the JobKeeper payment operates as a partial subsidy of that employee's wage. Employees who are earning less than $1,500 a fortnight will receive $1,500 a fortnight, and so the subsidy will top up their remuneration to the $1,500 amount. On the other hand, employees who are currently stood down and receiving no income, in that context, you need to pass on the subsidy in full to ensure that those employees receive $1,500 per fortnight. Now, as I think Ethan and Paul mentioned earlier, it's possible that some employees might work for multiple employers. If it's the case that they're going to be claiming JobKeeper through you and not through their other employer, then you would still need to ensure that you pass on whatever amount of the JobKeeper payment is necessary to ensure that the amount you are paying them is $1,500, regardless of what they might earn elsewhere. Now, Paul, did you want to say something about how the JobKeeper payment interacts with employees on leave?
Yes, thanks, Kylie. Well, the key point here is that employees on paid or unpaid leave are eligible for the purposes of the scheme, so that if you have employees on leave, you can claim in respect of them and receive the JobKeeper payment. Just in the same way as applies if an employee was continuing to work, you would be required to ensure that they receive whatever their entitlements are for their leave. And in effect, you would be receiving a subsidy which would be paid towards the amount that you're paying in respect of their leave whilst they're away from work on leave. I've heard some stories about employees being a little bit upset about this arrangement and suggesting that why should the employer be subsidised for paying for my leave entitlements. I mean, the alternative for the employee, if they don't wish to use up their leave in these circumstances, may well be for them to be stood down. If they're stood down, then they would only receive the $1,500 a fortnight. If, however, they're on leave and assuming that their leave entitlements exceed that, then in that sense, they're going to be better off than if they were simply receiving the stand-down payment, subject, of course, to the fact that they would be using up their accrued leave. And we're going to talk a little bit later about various directions that can be given requiring employees to take leave where that's not unreasonable in the circumstances, which will, I think, dovetail into this issue.
Thank you,
just
Paul.
In summary there, Paul, sorry to jump in, but with the annual leave piece, like we've had multiple examples with clients where you know, they've obviously sent staff on annual leave, and obviously the goal is to just be subsidised, like you spoke about. Employees are coming back with questions saying, like I said before, you know, why is sort of my leave being subsidised by the JobKeeper, where some employees are going, well, why don't I get 1,500 JobKeeper and then I'll top up with my annual leave? But effectively what I'm seeing here is that the employer is still well and truly entitled to pay the full leave, and then that 1,500 will just be a subsidy back into the business.
That's absolutely right. I mean, the employer is still paying them for that period of leave. So the rationale being that there's still a valid rationale for subsidising that. You don't double up, you don't receive 1,500 and then whatever the balance is to make up the balance of your leave. That's right.
Okay. Yeah.
So I wanted to say something brief about superannuation, and that is that employers can choose whether or not they make superannuation guarantee contributions in respect of any additional wages paid because of the JobKeeper payment. And I'm going to just run through these examples very quickly because I'm conscious of time. So where someone is earning more than $1,500 per fortnight and the employer receives $1,500 as a subsidy, that employee is entitled to super in respect of their normal wage. Conversely, if an employee earns less than the $1,500 amount per fortnight and therefore the subsidy tops up their remuneration to $1,500, in that case they're only entitled to super on their normal wage, and it's optional whether they get super on the topped up amount. And equally, where someone's currently stood down earning nothing, they'll be entitled to the $1,500 amount, and again it's optional whether or not the employer pays super on the entire sum. I now wanted to move on to what businesses should be doing now and over the next few weeks. As we might have mentioned, participation in the scheme is voluntary. It's an opt-in scheme. And so for now, you should be considering whether or not you're going to satisfy these eligibility requirements, register your interest with the ATO, subscribe for JobKeeper updates, and start notifying employees that you do intend to apply for JobKeeper on their behalf, get clarification from them, then they're not intending to claim through one of their other employers if they have one, and start asking eligible employees to complete the nomination form that Paul mentioned earlier. So that's what can be done now. From the 20th of April, which is next Monday, businesses can go online and enrol for JobKeeper payments. This is through the ATO website. You'll need to provide bank details, indicate whether or not a business owner is claiming, and specify the estimated number of eligible employees. And as I think Ethan said earlier, it's important to enrol before the end of April if you do wish to claim JobKeeper payments in respect of the month of April being the first 2 fortnightly periods. If you don't, then you just need to apply by the end of the fortnight that you're applying for. After that, from the 4th of May, you can apply to claim the JobKeeper amounts by logging on to the ATO business portal. An online application form will need to be completed, and that's where you'll identify specific details about your eligible employees. And you've then got 7 days after doing that online form to notify eligible employees that you have nominated them. Thereafter, there are some ongoing monthly reporting requirements to the ATO. You'll need to keep reconfirming that your eligible employees haven't changed, and you'll need to provide details of current GST turnover and projected GST turnover on a monthly basis. So I think we will now move on to discussing these new JobKeeper enabling directions, as they're called, which were introduced very recently into the Fair Work Act. And these amendments took effect on the 9th of April, and at this stage will operate until late September. And essentially they entitle employers who do qualify for the JobKeeper payment to temporarily implement some new flexibility measures with respect to their employees' working arrangements. So I'm going to go through a number of the new directions that can be given to employees. The first direction is in relation to reducing an employee's working hours. And so it's now permissible to give a direction to reduce someone's hours down to 0 if the employee cannot be usefully employed in their normal days or hours of work because of COVID-19. So this might cover a direction to not work a particular day or work less hours on a particular day, or reduce their ordinary hours of work overall. There are a couple of requirements which Paul will talk about a little bit later, but in this context there's a requirement that any direction be safe, having regard to the virus. A direction also will not apply if an employee is on leave, whether it's paid or unpaid. And employees who are given a direction do have the right to request to engage in secondary employment or undertake training or professional development. And there's a requirement in the Fair Work Act that an employer not unreasonably refuse such a request.
Just a question there, Kylie, one that came through earlier was around, and I've seen it a little bit, is, you know, people trying, or sorry, employers trying to sort of cap out their staff's hours, so they're at that sort of $1,500 threshold. So effectively, it's pretty neutral to the employer. What would, I guess, be your thoughts around, you know, how the employer tackles that and sort of the practicality of that with the awards coming into play?
We might come back to that question once we've gone through some of the requirements for issuing a direction, including that the direction not be unreasonable in all the circumstances, and then we can address all of that at the same time. I think might be a bit more efficient given our timing at the moment. So our second direction that's permissible is to alter an employee's duties. And again, there's some criteria, including that the duties be within the employee's skill and competency, the employee be sufficiently licensed or qualified to perform those alternative duties. And again, as I mentioned, this is subject to the employer qualifying for the JobKeeper payment in respect of the employee. The third direction that's now permitted is to change an employee's place of work, which may include to their home. Again, there's some requirements, including that the location be suitable, not require the employee to travel an unreasonable distance, and that performance of duties at that place be safe. Now, I mentioned there's some requirements for issuing these kinds of directions. I think Paul was going to say something about that.
Thanks, Kylie. Yeah, the overall requirement in respect of any JobKeeper enabling direction is that it not be unreasonable in the circumstances. Now, that obviously begs the question of what does unreasonable mean? Primarily from the employer's point of view, it would boil down to their operational requirements and having regard to the amount of work that they have on and the requirements for employees to undertake the particular work. It's important here to be able to show and to be able to show in a documented way in the event that you need to prove it in evidence, in the event that there's any kind of dispute about this, that you've undertaken an objective assessment of the reasonableness of the need for example, the reduction in hours having regard to your operational requirements and projected financial position going forward. In respect to directions about changes to duties or work locations, there's an additional requirement that the employer must have information available to them from which it's reasonable to believe that the direction is necessary to continue the employment of one or more employees. So it need not be to continue the employment of that particular employee, but it might be one or more other employees that might be adversely affected if the direction is not given. So again, that boils down to being able to demonstrate, having regard to financial circumstances, for example, if the direction is not made, and taking into account any JobKeeper payment received, that the employer really needs to give that direction to ensure that it can maintain the employment of one or more employees when but for the direction, i.e. if that employee was to continue on their normal wages, the employer would not be in a position to keep them on and would have to make them redundant. So again, I think it's important to have competent internal or external advice about these matters before you go ahead and make a direction. That's really what I wanted to say about that, Kylie. The other requirements for issuing directions are that you must give notice and consult with the employees. So you must give at least 3 days written notice or a shorter period if that's agreed. What is consultation? Well, consultation is generally understood to be giving the employee a genuine opportunity to have input and suggest alternatives and discuss it with the employer. It's very likely that the general award requirements for consultation will probably be enlivened in this sort of situation in any event where major workplace change occurs, and very much the same obligations apply, although here you've got a fairly short period of notice, not surprisingly in the circumstances. Directions must be in writing, not surprisingly again, and will continue into in effect until 28 September 2020 unless they're withdrawn or revoked before the end of that anticipated COVID-19 effect period. Then there are some, I guess, protections or conditions that apply in the event that you are giving a direction. Firstly, that you must ensure that for each fortnight the participating employers must pay each eligible employee the greater of either $1,500 or the amounts that they would be entitled to for their ordinary work or leave payments, including penalty rates and the like for that period. If you don't do that, then you're not eligible, and you're going to be exposing yourself to potential liability for breach. Where there's a job direction, JobKeeper enabling direction in place, that period counts towards the employee's overall service. That's really just a clarification, I think, of what would ordinarily be the position. But what it does is it doesn't reduce any accrual by reason of any reduction in hours during that period of time. Leave entitlements will continue to accrue, and other service-related entitlements such as redundancy and notice of termination will be calculated as if the direction was not given as well. I mentioned that there are some consequences if you don't do the right thing here. One of those is you can be liable for a civil penalty in circumstances where you knowingly make an unauthorised direction, and there are some fairly significant penalties in respect of each contravention which apply. In addition to that, there may well be other potential liability that arises in these circumstances for breach of other workplace laws. So again, the exercise portion is the message here. Make sure you get it right.
Now, I just wanted to talk about 2 additional flexibility measures that have been introduced into the Fair Work Act. And the first is an employer's right to seek agreement with an employee to change their days of work. And where an employer makes this kind of request, the employee can't unreasonably refuse to agree to it. Now, that's subject to a couple of caveats, including that the effect of the request not reduce the employee's overall hours of work, and the performance of work being safe, having regard to COVID-19. The second new flexibility measure is in relation to annual leave, and it's twofold. The first is that an employer can request an employee to take a period of annual leave, and provided the employee's remaining leave balance will be at least 2 weeks, the employee must not unreasonably refuse to agree to that request. The second aspect is that parties can agree for an employee to take twice as much annual leave at half pay, and that's a similar entitlement to what has been recently inserted into around 103 modern awards, which we'll talk about in a moment.
And Paul and Kylie, just with the annual leave part there, have you seen much around long service leave and how that will play out as well? Is that pretty similar?
Kylie, did you want to go?
Long service leave comes from state legislation. Each state has different laws in place with respect to long service leave, whereas annual leave comes from the National Employment Standards and is universal around the country. So what we're talking about here is limited to annual leave. The Long Service Leave Act in South Australia, for example, provides that it is to be taken as soon as reasonably practicable after it's accrued, and an employer can direct an employee to take long service leave on 60 days notice. The other acts will have similar or differing provisions. And again, in South Australia, there are some exceptions to what I just said, where parties can agree to taking long service leave in advance of accrual, or in different periods of time than that's specified as the norm in the legislation. So that really needs to be considered on a state-by-state legislation basis.
Yeah. So
the next topic we wanted to address was some of the flexibility introduced into modern awards. As Ethan mentioned at the start, there's some new entitlements that have been introduced into more than 100 awards, including the right to take unpaid pandemic leave and rights in relation to annual leave. So the way unpaid pandemic leave works is that any employee, whether they're full-time, part-time or casual, may take 2 weeks of unpaid pandemic leave in particular circumstances relevant to COVID-19, which appear on the slide there. you don't need to have exhausted your paid leave entitlements before being able to access unpaid pandemic leave. And the rationale for this was there was concern by the Fair Work Commission that a number of individuals are being required to self-isolate, not attend their usual workplace, for example, because they have come into contact with someone who has coronavirus. And so if they're not actually sick themselves, they don't qualify for paid sick leave entitlements, and therefore they're really at the mercy of being able to reach agreement with their employer for them to take special unpaid leave. And therefore the concern was that an employee in that circumstance would be faced with choosing to disobey a direction to attend work by their employer, or disobey a health direction and potentially commit some kind of social distancing or self-isolation offence. And therefore that's the reason this entitlement has been introduced into a large number of awards, and the awards selected are those which cover industries most likely to be affected by the circumstances, and those which have a high number of award-reliant employees. The second new entitlement is similar to what I mentioned earlier, which is that parties can agree to take twice as much annual leave at half pay. And both of these leave entitlements require the leave to commence before the 30th of June this year, but the period of leave may extend beyond that date. And some similar as well as more generous entitlements have been introduced into the Clerks Award, the Hospitality Award, and the Restaurant Industry Award. Those awards were the first to be amended a couple of weeks ago, and there's some additional flexibility around directing employees to take annual leave, directing employees to change their duties, directing employees to reduce their hours of work, and alike. Now, I think we wanted to finish off with some discussion around some general strategies for managing employment arrangements. We might try and weave in an answer to the question you raised earlier, Ethan. I'm not sure if Paul might want to go through a couple of matters on the slides at the same time.
Yeah, so I'm conscious of the time and allowing some time for answering questions, but so really the intention of this part of the presentation was to summarise, I suppose, what options are available based upon the new JobKeeper scheme, the amendments to, or the temporary amendments to awards in respect of leave, which extend in some cases to being able to give directions to take leave, which are more favourable to employers than were previously the case, particularly under those the Clerks Award and the Hospitality Award that Kylie mentioned. We've obviously got the capacity to request, and an employer cannot unreasonably refuse leave under the JobKeeper scheme. So that's available. All of those things are available to somebody who qualifies, in addition to the usual general law options for reaching agreement in respect of leave that would apply to employers generally. So if one does not qualify for the JobKeeper payment scheme, then obviously you can't rely upon that, receive the payments or give JobKeeper directions. But there are other options that remain available to you, as I mentioned, in respect of those temporary award amendments, and in respect of award-free employees, for example, you can give a direction that an employee takes leave if it's reasonable, and that may be in circumstances where they have an excessive accrual, the business closes, or there's some mandate that the business, there's a government mandate that the person or the part of the business be isolated or quarantined. Otherwise, generally, one has to reach agreement with an employee that they take leave, particularly if they're a non-award employee and you can't rely upon those more flexible award provisions. And then there are other options that are available either by agreement or under the terms of those particular awards to require leave to be taken in advance or at half pay. So just touching really, I suppose, on the options that are available, and it would depend upon the particular business, the particular employees in question as to what approach one takes, and it may well be a tiered approach in terms of seeking agreement, and if agreement can't be obtained, looking at what your options are in terms of giving directions. And we've already touched on long service leave. Kylie's already answered that issue, I think. And finally, the most drastic options, if you're not in the JobKeeper space, is exercising stand-down rights, which can apply under the Fair Work Act if there's the person cannot be usefully employed due to let me just get the terminology. Due to a business close down in effect, or part of the business closes down. That's still available even if you're not in the JobKeeper space. And obviously then if we get down to redundancy being the final option, one needs to look at how you protect yourself in terms of undertaking proper consultation and complying with your redundancy obligations so that you're not exposed to claims. So there's obviously a lot to unpack in all of those things, but given the time we have available, just by way of a brief summary. So I think it might be over to you now, Ethan, to have a look at some questions.
Yeah, thanks, Paul. I think we've got probably about 5 or so minutes, so we'll just try and get through some of these questions that have come through from the attendees, a lot of relevant ones here. So we've got just a question here: does the month of March have to be measured in isolation, i.e. delaying the start till 1st of April or qualifying in April enable a claim effective for the second half of March? So my response to that one would be that really the JobKeeper is effective from the 30th of March onwards. So it would be looking at sort of these months, and in particular April, as when we looked at sort of the projected turnover, but it's really going to be effective for that first fortnight of pay in April onwards. So I think some people are just getting a little bit confused with the effective date being obviously the 1st of March that the employees were on board at that point. We had another one around, can the employer record $700.50 a week payment as annual leave? So as we went through that, obviously coming to the agreement with the employer that annual leave is a possible pathway, so that would indicate that that would be $1,500 a fortnight. So Paul and Kylie, that all aligns there, doesn't it?
Yes, if the employee is on leave, effectively you're receiving a $750 a week subsidy towards those leave payments, if I'm understanding the question correctly.
Yeah, cool. We've got another one here, a detailed sort of question here, but effectively saying that employees fall into 3 different categories. Existing employees receiving more than $1,500 on a fortnightly basis, part-time that may be topped up, those employees currently receiving 0, so they may be casual or stood down along those lines. So the first requirement is to nominate all existing employees that are eligible for the JobKeeper subsidy will be reimbursed in May for 2 payments in April. So there's quite a bit in that question. I think to keep it simple, it's about obviously identifying eligible employees and then going down the nomination pathway. Probably the third and most important requirement there is that you actually are then making the payments at the same time throughout April. So you are then eligible for that reimbursement in early May. But happy to take that question offline with whoever sent that through. Another one here, I have a partnership, both of us are actively working in the business. What can we do so that both of us can claim? I think the way I read it, Paul and Kylie, correct me if I'm wrong, but obviously it's spoke about in terms of business participation. It's only sort of one partner at this point in time. So unfortunately, that would be the way I read that, is that it is only possibility for one there. There's obviously other incentives through the cash flow boost that are available, but yeah, unfortunately, I see it as just one eligible partner in that case.
Yeah, I agree with that, Ethan, absolutely.
Yep. just a few more minutes ago, we'll try and get through as many as we can. Our pay fortnight is the 2nd to the 16th of April. Can we just continue on those dates, or do we need to pay from the 30th of March pro rata? So based on your pay cycle, it still looks like you'd have a pay run hit on the 1st of April, and then obviously the one on the 16th of April. So I think those two would fall into the JobKeeper fortnight cycles for the month of April. You've obviously then got another one falling on the 30th of April. So we have seen a little bit come out the last few days on the pay run cycles and how they fall in. It's obviously new information release that we've got to get across, but I still think that due to the fact you've got that earlier fortnight, as long as the JobKeeper is kicking in, you should be fine for the month of April on that basis.
Yeah, and there is a specific provision in the rules that says if you don't pay on a fortnightly basis, then the ATO will assess the fortnightly amount on a reasonable basis. So that's probably worth noting as well. You don't have to be paying on a fortnightly basis for you to be covered in respect of the wages that you pay in respect of that fortnightly period.
Yeah. We might just answer a couple more before we wrap up. What we've got here. I had one that might be suitable here. You might be able to talk through this one, Paul and Kylie. What happens if you have to dismiss an employee that you have been receiving JobKeeper for? Can the replacement employee take over the JobKeeper payments?
It's a good question, not something I've thought about. I don't think so, based on the rules. I don't think there's any provision for that at the moment. So the answer would be no, the entitlement would cease, which is perhaps a bit of an unfortunate consequence, but I think that's how things stand at the moment.
Yeah, I think thinking about that as well, I agree that obviously if you're receiving the JobKeeper, the employee that you have dismissed is an eligible employee, so they would have been entitled to that JobKeeper payment. Obviously for replacement employee, they're not really going to satisfy then that rule at the 1st of March if they're a new employee, or if another employee, they should have been getting the JobKeeper already. So unfortunately, everyone, there's a few more questions, but we're just running out of time this afternoon. What we will endeavour to do is to reach out to you all that have left sort of remaining questions there. I think we've got contact details, so we make sure we reach out just so you can get clarity on these areas. So I guess in summary, wrapping up, thank sort of Paul and Kylie for your time today. I think the information you've provided, especially around the JobKeeper and employment law aspects, is highly valuable as we see sort of employers trying to navigate through the JobKeeper side and just sort of the whole employment law aspects. So yeah, thank you both for your time today. Obviously, if any people have any questions, post this. Our details will be available on sort of the information provided post this, so feel free to reach out to the three of us if you have any questions. We're more than happy to help because everything does seem to be changing a lot at the moment. And so if you do require any support throughout this ordeal, please feel free to sing out. So yeah, we thank you all for your time and have a good rest of the day.
Thank you, everyone.
Thanks, everyone.